Thanks for staying with us on NDTV Hindu's special show Bill of Rights. This is the third and final segment today. Now here's a story that is quite a shocker. A failed tubectomy surgery and a court ruling in favor of the patient sparked quite a debate, and not merely among the legal fraternity. The case we now bring you highlights the need for increased awareness about the lesser known facts on the methods available to avoid getting pregnant. Our consumer reporter Bertla brings you this story of a woman who was quite taken aback, to say the least, when she became pregnant despite the surgery she underwent.
As a family planning move, a woman was advised by health workers in the Chennai Corporation to abort her pregnancy, which was less than 12 weeks old and legal. She was also advised a tubectomy surgery to avoid unwanted pregnancy. But the woman was baffled when she became pregnant even after the surgery. She took her concern to the court.
The law forum held that it is due to the medical negligence, it happens again the pregnancy, hence awarded rupees 25,000 for medical negligence and rupees 25,000 for the mental agony and sufferings and rupees 1,000 for the cost.
But medical research shows tubectomy is not 100% fail-safe and medical negligence is disputed in such cases.
As per the medical literature and other things, it is only 90 to 95% successful to all the patients. So there are every time there is a possibility of 5 to 10% of reconceiving after the operation is done. Hence the Supreme Court, Apex Court as well as held that it is not a medical negligence and it is not a deficiency in service.
While family planning campaigns have gone far and wide, this case appears to underline that facts about tubectomy and lesser known details of pregnancy prevention methods should get more emphasis, especially among the uneducated population. In Chennai, Bertla, NDTV Hindu.
Well, let's listen into what our special guest has to say about this report and similar situations that people could face.
What we saw just now was a case where she underwent a tubectomy operation. That's different from abortion. It's a case where the fallopian tubes which lead to the uterus are, tied up, or maybe they are cut. So that was a case. In fact, I had gone through the order. It says the person was already pregnant because one of the exhibits filed by the doctors state, exhibit B4, state that the person was already pregnant. She had gone to the hospital for an abortion and for tubectomy operation. So she was already pregnant then. Now the question of whether tubectomy is 100% safe and secure, they would say no, because the statistics say 0.3% to 7% it is not.
Okay.
So an education, in fact the Supreme Court has consistently held that failed tubectomy is not necessarily a medical negligence. See, because negligence warrants three issues. In Jacob Matthews' case, the Supreme Court has said, first, negligence means there is a breach of duty, a reasonable skill and care a person is expected to exercise has been not done. The second one is the person is not possessed of the skill, but he proclaims that he has that skill. Okay, and the third one is an issue where he has not taken a proper care. So these are the issues. Now in this case, we find that the person was already pregnant and she had gone. In the case of the complainant before the consumer court was, she had gone in for abortion and for sterilization. But when she went back to the hospital, she was already she was already pregnant. It appears as if the abortion was not done.
All right.
Yes.
So do you get a lot of cases where tubectomy cases have failed to work? Have you come across many of those?
See, the ratio says it is 0.3 to 7%. There are cases where failed tubectomies come before the courts. As latest as July 2010, the Madras High Court has held in two cases, that is in Kairanvisa and IMR. In both these cases, it was a case where an appeal was filed to the High Court from the District Court. It was a second appeal, where the court said, following judgment in Shivram versus State and an earlier judgment of the Supreme Court in Raj Rani versus State, stating that failed tubectomy does not necessarily give rise to medical negligence. See, one more thing we should see in this case, it's a government hospital that has performed the surgery. And normally I would only say that the doctors in the government hospital are a very, a lot which suffer a lot, because basically their pay scales and all those things are very less, and the kind of facilities you have in a government hospital is not necessarily to the standard expected. And here I do not want to comment about the case as such, but it appears as if it is a case of unwanted pregnancy and tubectomy also.
Can the hospital be also held accountable?
Hospital can also be held accountable because there is a judgment of the Supreme Court once again saying Savita Garg versus the state, wherein the court had said that because the hospital employs the person, there is a vicarious liability.
So do a lot of patients approach you with cases relating to tubectomy that they suspect is part of medical negligence? What are some of the misconceptions that they come with?
Generally about medical negligence, people who come to a lawyer are not totally well informed. So that is why a concept called informed consent comes into play. So before a surgery or a procedure is taken on a person, the person has to be informed about the procedure, what is going to be done on him or her. So that has become one of the essential requisites now in the case of medical negligence. In case I am not informed that this is the operation that would be performed on me, then it's a case where it will be a cause for medical negligence later on.
Alright, what is the basic thing that you would tell our viewers? What are the norms that they should follow? As in, when they end up facing trouble like this way, how do they approach the consumer court or even the advocate to take the case ahead?
See, the first thing they have to keep is the records. Okay, the records have to be properly maintained. I mean, it's something like the courts would only rely on the evidence that is produced. Oral evidence also has to be supported by documents. That is the basic rule of evidence. In case like I state something without me substantiating by producing the documents. Like in this case, one of the documents that was produced by the consumer, from what I read in the judgment, says that she had gone in for abortion as well as for sterilization. But it appears that after 23 weeks, she realizes that she is pregnant and the abortion was not done on her. So, and though the tubectomy may have been successful, it appears that the unwanted pregnancy was not done away with. Okay. In fact, if I may say, see, Section 3 of the Medical Termination of Pregnancy Act gives the person that in case they want to, get ahead with termination of pregnancy, they can go and have it done.
Alright. Apart from the compensation that the consumer court gives the person, what sort of action can be taken against the hospital? Can they be sued?
They are sued, that's why they are before the consumer court. One more thing would be a criminal breach of trust where it occasions into something more, that kind of thing can be done, a criminal complaint or something like that. But the issue is whether there has been a negligence has to be established prima facie.
Exactly, but to establish that, like you said, you need certain records. But would the patient be able to access those hospital records? What if you are unable to access it?
No, you can have an advocate commissioner appointed by the consumer court who can go and seize the records, go and get the records from the hospital.
Alright, how do you go about getting the advocate commissioner to
you
come
file
to
an application before the consumer court, ask for the assistance of the court to have an advocate commissioner appointed, because there are cases sometimes where the records in the hospitals are manipulated, overwritten or later on it's filled in. So in order to avoid it, at the earliest point when the case is taken up before the consumer court, an application for appointment of advocate commissioner has to be made so that they can go and seize the documents.
Alright, okay. Now, what are some of the other common family planning methods that people sometimes have problems with and approach consumer courts? What is the more common problem that comes before the courts?
It's not only family problem cases relating to medical negligence that come to the lawyers before the consumer court. There are other cases relating to negligence, medical negligence also. Any operation which a doctor undertakes to perform, if it results in a failure, I mean if it's a misadventure, mischance or some kind of thing which was not expected, that is not negligence. There should have been a breach of duty. Negligence means a breach of duty which has been undertaken to be performed by the doctor, where he has failed to exercise that care. Degree of the expected degree of degree of skill and care has been failed to undertaken by.
So would it help to get the expert view of another doctor in the matter to try and prove your case? In case you suspect medical negligence.
Earlier on, the Supreme Court had actually stated that in Martin de Souza's case, that a doctor has to necessarily, it has to be put before a panel of doctors. Like it was something that was a bit of a ticklish issue, because no doctor would come and testify against. We face that problem in the consumer court. Then we have to issue a subpoena, I mean summon a doctor who works in a government hospital or something like that. Otherwise, it's difficult to get doctors to testify against another doctor. Then later on, the Supreme Court Justice Sinha had said it is not necessary that a doctor or the case has to be, because the consumer complaint would not be numbered unless otherwise the doctor says it's a fit case for being taken up.
Well, that's all we have for you this weekend on the show. Do remember to catch the Bill of Rights segment on our special breakfast show, Good Morning Chennai, on Mondays, Wednesdays and Fridays between 7:30 and 8:30 a.m. That's when you can call us live on 3063-2994 or 3042-7777 and talk to a consumer rights activist directly for a solution to your problems. You could also write to us at feedback@ndtv-hindu.com and tell us not just what you thought of today's Bill of Rights, but also about any consumer related issues that you would like us to take up. This is Cuckoo Alex signing off for now.